All right, we're getting started. Glenn Roper's back. We're talking about constitutional law. Give it up.
All right, good evening, everybody. I've got my lawyer suit on. I spent actually all morning here. Oh, you're not on. Hello, hello. That seems like. Oh, that seems. Okay.
Now, of course, this is freaking out. Here, use that one.
Let's see, can I fit this in here?
Reed will cut this part out of the video.
All right, how's that? Can y'all hear me? Okay. Yep. Anybody here? Josh and I were talking. I think I was last here 3 years ago. Anybody here when I came last time? Tom was. Kyle may have been. Okay. Important question. Does anyone feel like they're not able to take me seriously if I lose the tie? Okay. All right. I'm going to lose the tie here. Excellent. All right. Like I said, I spent all day, all morning here at Independence Institute at a continuing legal education class about DEI mandates. So that was kind of fun. My name's Glenn Roper. I'm a senior attorney with Pacific Legal Foundation. I live here in Colorado, although we're a national organization. We started in California, which is where the Pacific comes from, in Pacific Legal Foundation. But we've expanded and really now have a national reach. So let me turn off the. Let's see. I put it on black screen. Let's see if I can take that off. All right, excellent. So what is PLF? Put simply, Pacific Legal Foundation is a libertarian public interest law firm. We represent clients free of charge when the government infringes or gets in the way of their rights, and that's what we do. We sue the government. Most of our clients are not large institutions. They're farmers and ranchers and small business owners and parents who find themselves on the wrong side of government power. And most of our clients didn't wake up one morning thinking, I want to go be a plaintiff in a federal lawsuit. They're usually not looking for a fight or trying to make legal history. They're trying to do something simple: build a house, start a business, choose a school, serve their community. Then the government shows up and says, no, not unless we give you permission. So that's where PLF comes in. So we're divided into 4 main practice areas, and I listed them up here: property rights, environment and natural resources, separation of powers, and equality and opportunity. Those labels can sound a little bit abstract, but the cases are not. They involve homes and family businesses and the right to build and work. And we've been very successful. We've had 18 victories in the United States Supreme Court. And that's a great track record for any sort of legal organization, especially for a nonprofit public interest firm like us. So we're very proud of that. We're hoping for a 19th win soon. We're waiting for the Supreme Court to decide our property rights case, Pung versus Isabella County. I'll talk about that a little bit more later, which that should come out sometime this month. Hopefully that'll be another victory, another notch in the belt. That Supreme Court record matters not because lawyers like trophies, although to be clear, lawyers like trophies, but because the Supreme Court cases set rules for the entire country, right? When PLF wins a case at that level, the benefit is not limited to just the client whose name is on the case caption. It extends to everyone across the country. Everybody is protected. And PLF can provide a better constitutional rule for the country when we can get a Supreme Court victory, even for people who may never even meet a PLF attorney. So that's often our ultimate goal is to get to the Supreme Court and to get a victory there. And we're very proud when that happens. But I don't just want to give you a PLF resume tonight. I want to give you a sense of the people behind our cases and the principles that connect them. So there's a common theme that runs through a lot of our litigation. Government takes something that is a right and turns it into a permission slip. You want to use your own property? You got to ask for permission first. You want to build homes? You got to pay a massive cost, affordable housing fee as a condition of approval. You want to start a business? First, you got to prove to your competition that there's a need for another competitor. That is not a free society. That's a permission-based society. And PLF's purpose is to get involved when the government crosses the constitutional line. So government officials usually don't come out and say it that bluntly. They're not going to announce, we're here to convert your right into privileges. They use softer words like sustainability or equity or community benefit or administrative discretion. And some of those words can describe real concerns. I don't want to minimize that, but they can also be camouflage. And when you scrape off the rhetoric, the underlying claim is often this: your liberty exists only if the government agrees that you've made a sufficiently good case for it. That is exactly backwards. In our constitutional system, the citizen does not bear the burden of proving to the government why he or she should be free. The government bears the burden of proving why it can justify its restrictions on freedom. All right, so tonight I'm going to give you examples of a few of our cases, from medical care to public contracting to childbirth to property rights, and we'll talk a little bit of Colorado as well. I want to leave lots of time for questions as well. But let me start with one of the clearest examples. And I shared this one 3 years ago, but it's a very poignant case, I think, so I want to share it again. Imagine a horrible situation. You have a child with a rare and deadly form of cancer. And then imagine there's a doctor who can treat that cancer, but she lives in another state, hours away. Well, of course, you'll make that trip for things like chemotherapy and radiation and surgery. But how about if it's something a little simpler? What if you just need a follow-up conversation? What if you need to review scans or ask some questions? Well, for almost every part of modern life, you'd have a phone call or you'd set up a Zoom meeting, right? For that. It seems pretty commonsensical. But there are some states that ban doctors from having those calls or those Zoom meetings. So PLF, we represent June Abel, who's a young teenager who developed a rare and serious form of brain cancer. One of his doctors is Shannon McDonald, who's a pediatric oncologist at Massachusetts General Hospital, one of the best hospitals in the country. She's a specialist. She's one of the few in the country, in the world, that has an expertise in this particular form of cancer. So June can receive care from her when he physically travels from New Jersey to Boston. But New Jersey makes it illegal for Dr. McDonald to have a phone call with June or a Zoom meeting with June because she does not also have a New Jersey medical license. Okay? And that's the kind of law that sounds superficially protective, right? We're protecting patients, the government says. But who are they protecting June from? His own specialist? His parents? His medical team? This is the kind of thing that can make people cynical about government. So if a doctor is unqualified, don't let them practice. If they commit malpractice, punish them for that. If someone is pretending to be a physician but isn't qualified, punish them, keep them out of the profession. But that's not what's happening here. This is a licensed, highly qualified specialist who has a relationship with an ongoing patient, but is unable to provide that care unless he gets in the car and drives across the state line. Now, we'll all remember that during COVID, many states relaxed their telehealth restrictions and allowed these kinds of conversations across state lines because of all the restrictions that were going on due to COVID, and the sky did not fall, right? But then when the emergency, the COVID emergency ended, there were some states that started to ramp back up those same restrictions, and that's the case with New Jersey. So our argument in June's case is that the Constitution does not allow states to wall off their residents from getting appropriate medical care from specialists. And I'll tell you, if you want to have a compelling, a sympathetic plaintiff, a child with brain cancer is a pretty good place to start. as an attorney, and so going to court and representing June is a privilege. Um, we also have a First Amendment free speech claim in this case, because what we're talking about, Dr. McDonald doing, is just talking on the phone, right? This isn't providing surgery remotely or some sort of procedure. It's just a conversation. The upshot of New Jersey's restriction is this: I can speak to someone in another or in New Jersey, or have a video call about fantasy football, or tax returns, or fixing my dishwasher. But in New Jersey, that shouldn't be converted into a crime just because it's a discussion about a health issue, a child's cancer treatment. All right. So let me turn to equality now, another area that we focus on. In our equality cases, PLF is trying to enforce a simple principle. Government should treat people as individuals, not as representatives of their racial group. I'll show a slide here. I don't know if anybody recognized this person. Yeah, no, this is a real individual. Maybe a younger crowd. Anybody ever heard of Alex Earl? All right, wrong. Maybe you have, Josh. Yeah. She's a TikTok influencer, online personality, social media person. Alex is not a PLF client, but her dad is a PLF client. So we're excited about that. Her dad, he and his brothers own an asphalt and paving company, also in New Jersey. I'm realizing these first two cases both come out of New Jersey. It has been a non-union business ever since its founding, and what they do, they provide paving and construction services. They've been recognized nationally for their commitment to second chance hiring, where they open their doors to formerly incarcerated persons or people who've struggled to find work. About 80% of Earl Asphalt's business comes from contracting with the state of New Jersey or cities in New Jersey. Building roadways, installing sewer systems, repaving the New Jersey Turnpike. That's what they do, and most of their income comes from that. However, New Jersey has a law requiring every contractor on public works projects to meet quotas for employing racial minorities. That is, they say if you want to work for the state of New Jersey, if you want to bid on our contracts, you've got to prove that you've got a certain percentage of racial minorities working for your business. Or if you don't do that, you're required to partner with a union who will supply the racial minorities to work on your project. So think about what that means in real world terms. The state isn't just saying, do the best job that you can. They're not saying, build the road safely and on time and on the best value for taxpayers. Instead, it's saying you have to manage your workforce according to government racial targets, or else you have to partner with a union if you don't hit those numbers. So that's not equality. That's social engineering, hidden under the public contracting process. So in our view, the Equal Protection Clause of the 14th Amendment, a lot of our cases rely on that 14th Amendment, Reconstruction Amendment. It limits the government's ability to classify people based on race. And our argument is that New Jersey can't justify having these random racial quotas and enforcing them on people to be able to participate in the public contracting process. All right, so that's another of our cases. Let me shift gears to talk about babies. So this is one of my favorite recent PLF stories. This photo was taken in April, and this is the first baby in the history of Nebraska who was born at home with the assistance of a certified nurse midwife. And this is a result of a PLF case. So Nebraska has a bizarre structure when it comes to childbirth. All right. So a mother can give birth in a hospital, assisted by a doctor or a midwife. A mother can give birth at home without any assistance, but cannot give birth at home with the assistance of a midwife. That is banned in the state of Nebraska. Yeah. not with certified nurse midwives. They could give birth at home, and they still can. That's allowed today. So the state allows the riskiest form of birth without any sort of assistance, but won't allow you to give birth at home with the help of a certified nurse midwife, with a trained professional. And when I explain this to people, I'll get kind of this stunned reaction, like, no, you're missing something. But I'm telling you, that really is the law in Nebraska. You can give birth unassisted, but you can't have a midwife there in your home to help you. Leaf, did you have a? No. I think you can have them there if you don't pay them, right? So someone can volunteer to help you, but a midwife who's there seeking to practice her profession is not allowed to do it. So we represented Hope Lindstrom, shown in this photo. She wanted to give birth at home with the help of a certified midwife, consistent with her personal values and personal religious beliefs. So we brought due process and religious liberty claims. Because she was so far along in her pregnancy, we knew that we couldn't wait for a full litigation that can take years. So instead, we negotiated with the state and were able to get an accommodation for her to give birth at home. I think they realized we had some strong claims, and so they settled that particular case. It applied just to her, though. They weren't getting rid of their law. I'm not even sure that they could without a court getting involved. But the broader issue remains. The government should not force women into less safe choices by banning qualified professionals from helping them. And we may or may not be on the verge of bringing another case with other Nebraska mothers who are interested in challenging this same issue. But I love this picture. I'm glad we were able to get this help for Hope. And she was very appreciative and very glad that she was able to do this. Hopefully, in the future, it will be wide open and allow this more broadly. I highlight this case not only because I think it's an appalling law that they have in Nebraska, but also it reflects a larger problem. Across the country, states have built licensing systems, like the midwife licensing system in Nebraska, that has very little to do with protecting the public, and instead is geared towards protecting entrenched interests, like the hospitals that want to have a monopoly over midwives providing birthing services. Sometimes those laws are defended as consumer protection, but consumers aren't protected when the government bans safer options. Mothers aren't protected here by being forbidden from having professionals assist them when they give birth in the place and manner of their choosing. All right, let me talk about the Supreme Court case that we're waiting on. This goes into our property rights practice, and hopefully, like I said, hopefully will be our 19th victory. We won't know, and we had the oral argument at the Supreme Court. It's always hard to tell from oral argument which way it's going to go. Everybody likes to try to make predictions. I think it's very difficult to tell just from questions the justices asked. But let me outline this case for you. So this is the Pung family. They live in the state of Michigan, and I called this a property rights case. It's also a fairness case, and hopefully you'll get a sense of that. How it's a case about how abusive government can get when ordinary people lack the resources to fight back. So the Pung family, they owned a family home in Michigan. Okay. They were assessed property taxes. There'll be a little bit of math here, nothing too difficult. They were assessed property taxes of $2,000. They actually contested this. They thought they were entitled to an exemption. Some parts of the government agreed with them, some others didn't. The county decided to press forward. That's a little bit of an aside, but helpful background. And the county pressed forward actually with foreclosure. So the house had an assessed value of $194,000. Okay, because this tax wasn't paid, the county ultimately came in, foreclosed on the home, kicked them out, and sold the home at a distress sale auction for $76,000, and kept all of it. Okay, so that's the first piece. They sold the home, and the county just kept it all because that's what they were allowed to do under Michigan law. Now, if a private debt collector, like a mortgage owner, did that, everybody in this room would know what to call it, right? That's theft. You can't do that. But that's exactly what this was. The government came in, took a family's home over a small claim debt, and then kept the money. Fortunately, right around that time, PLF, my firm, won another Supreme Court case, Tyler versus Hennepin County, where the court agreed with us and held that the government violates the takings clause. And so it all went to the county. So the takings clause, probably the least known part of the Fifth Amendment, right? When people talk about pleading the Fifth, they usually are referring to the right to remain silent, to not be a witness against yourself. At the very end of the Fifth Amendment is this clause: nor shall private property be taken for public use without just compensation. Okay? That's a restriction on the ability of the government to take your property. It can do it if there is a public use and they provide just compensation for it. I think it's conceded that taking foreclosing on a property to pay a tax debt, that is a public use. They're using it for to get the public funds. And the question then becomes, what is the just compensation in that circumstance? So in the Tyler case, the government agreed the Supreme Court agreed with us that the government violates the takings clause when it takes more than it is owed in taxes. So that was a great victory, and that meant that the county couldn't just keep the full amount. And so what did they do? They returned $74,000 to the Pung family. All right? And let me put the numbers back up again here. So again, taxes owed, $2,000. Assessed value of the home, almost $200,000. They sold the home at a distressed auction sale, foreclosure sale, with, it's on a tight timeline. There's a limited buyer pool. You don't get to go inspect the house in advance. And so, the prices are lower. They sold it for $76,000. So the question in the Pung case asks what I said here at the bottom: what is the amount that the government has to return as just compensation? Is it the fair market value of the property at the time that it was taken? Or is it just the amount that the government was able to collect in their distressed foreclosure sale? That's an unanswered question, and it's one that is currently pending at the Supreme Court. Our argument is that just compensation has to be something more than just the depressed auction price, and instead should be the fair market value of the property. That's the position we're taking. The theory being that just compensation means compensation for what the government actually took, not just the scraps that were left over, based on whatever they decided to do with it. But that's up for the Supreme Court to decide, and we could find out as early as Friday this week. They'll be issuing opinions at least a couple times a week through the end of the month. The saying among lawyers is there's two kinds of people who get summer off: elementary school students and Supreme Court justices. They always take off between the start of July and the beginning of October. All right, so that's Pung versus Isabella County, an example of the kinds of cases that we get, and these can be difficult constitutional issues. I don't at all want to imply that this is a slam dunk. I think there's a lot of debate as to what is the proper amount of valuing the property that the government takes in this circumstance, and like I said, hopefully the Supreme Court will agree with us. All right. Let me talk about, I've been talking about things around the country. Let me talk about a few Colorado things. Because I think these themes, hopefully you can see some of the themes that I'm talking about in these different cases. Unreasonable restrictions, arbitrary government action, and these are the kinds of things that PLF is pushing back against. So one current PLF case that we have is called Red T Homes versus City and County of Denver, and it has to do with this affordable housing question. So our client would like to build some residential property, and the City and County of Denver said, okay, great, you want to build new homes? You can do that, but only if you pay a fee that's intended to help with the development of affordable housing, of low-income housing. And our challenge is based on a simple constitutional principle. Government cannot condition the right to build a home on paying for a generalized social harm that the home builder did not cause. Okay, and this is under a principle that is called the unconstitutional conditions doctrine. I don't know if anybody ever hear of that before. Yeah, this isn't in the Bill of Rights. It's not something where you can look at the unconstitutional conditions clause, but it's a doctrine that the Supreme Court has set out, and it under that doctrine, if the government demands money or action or services or some other concession as the price of a permit, it can only do that if there's a connection between what they're demanding and the actual cost of the project. So say, for example, you're going to build a new development that's going to add to the road traffic, to the congestion in the neighborhood. The government can say, well, as a condition of that, you need to help pay for widening the roads to help accommodate for the additional traffic that your development is going to create. And there has to be a connection between the demand and the actual impact. So what they can't say is, you need to pay to redo all of the Colorado highway system because you're building this development. It's got to be tied to that the effect of what you're seeking a permit for. So the government, in this case, in this Red T Homes, what we're making the argument is that the government can't just say, well, you want to build housing? You want to build new housing? Okay, well, first you have to pay us to solve the citywide housing crisis before you can have permission to do that. And as an aside, this is an illegal point, but there's also an economic point at work here. You do not make housing cheaper by making it more expensive to build houses, right? But somehow in housing policies, government keeps acting as if the laws of economics don't apply as long as you have a sufficiently righteous city council resolution. As long as you've got good intentions, then economics don't apply anymore. So as we all know, the supply of housing is at near crisis levels in some areas, and the supply of housing, the availability of housing, affects a lot of things about the quality of life, who can live here, whether people are able to live close to where they work, whether families can live near each other, and whether the city becomes a place for normal people to live or just a museum for people who bought in early, right? And so when a city says, we're going to make housing more affordable by charging more to build housing, we should all be a little bit skeptical. So that's the case that we're bringing there. Another regional issue worth watching is the oil and gas setbacks issue. We have a case in California addressing this particular issue that should sound familiar for those who follow Colorado energy policy. So our clients are the Morgan family, and they own, in Santa Barbara County, they own the mineral rights. And mineral, as a term of art, it includes oil and gas, right? Those are considered minerals under the ground. So they own the mineral rights to this particular area that includes oil and gas. Well, then California enacted a law saying there is no oil drilling allowed within 3,200 feet of homes, schools, hospitals, or basically any sort of public building. Yeah, yeah. So that's like 2/3 of a mile. So if you're within 2/3 of a mile of any of those structures, you can't have oil and gas drilling, and there's no restriction on where you can build those structures. So I think a creative anti-oil and gas group could build houses every 6,000 feet every mile or so, and wipe away people's ability to use their oil and gas rights, their mineral rights. So our argument there is that this restriction is essentially it's another taking, right? Remember that takings clause? It's making their mineral rights essentially unusable because of this huge restriction. And for those who aren't familiar with the industry, it's having a setback is not uncommon, but usually it's something like 200 feet, right? So to say 3,200 feet, 2/3 of a mile, it's a huge extension. And unfortunately, I guess so the claim we're making there is that this regulation has destroyed the economic value of the Morgan's mineral rights. And therefore, if the government is destroying that value, they can do that under the takings clause as long as they pay just compensation. So the government should have to. That's the argument we're making there. And we are seeing similar issues in Colorado, where there's been a big push on similar kinds of setbacks. There's a bit of a war against oil and gas in Colorado, and we've seen setback initiatives or city ordinances. I've seen them in 2,000 feet, 2,500 feet, vast extensions to everything that's been in the past. And so we're actually actively looking for people who may own mineral rights in Colorado and are affected by these proposed setbacks, where we could potentially bring a similar challenge here in Colorado. And then the last thing I'll mention for Colorado is building mandates. So there are local cities, including the city of Boulder, that have issued these regulations saying all new construction has to be electric only. You can't have gas appliances. The new build has to just be purely electric. And these raise constitutional questions on takings and restrictions. And they also show this broader pattern that I think is unfortunate, of the government using things like land use codes and building permitting to impose broad social goals on people, even if there's not a direct connection to public health and safety. So the pattern by now should be sounding familiar, right? You want to build? Then comply with our preferred energy policy. You want a permit? Then adopt our preferred labor policy. You want a public contract? Then satisfy our preferred demographic metrics. You want to use your land? Then prove that your project advances our policy goals. Those are the kinds of things that we're trying to push back against at PLF. And I think it really highlights, hopefully we've got some property rights advocates here in the group, where this is really where a lot of the rubber is meeting the road today, is in land use. The way that these broad policies are being enacted, the way that they're really coming to bear on people, is in the use of property, in the use of land, and in the takings context. All right. I've been talking for a while, but I do want to highlight one more PLF initiative, the Next Civil Rights Act. And if you go to this website, nextcivilrightsact.org, that'll take you to our webpage where you can learn more about this. As you all know, this year is the 250th anniversary of the signing of the Declaration of Independence. And so that is a fitting time to ask whether our laws still reflect the Declaration's promise of equal liberty. So PLF recently announced a legislative package, and they're all available on this website, designed to follow up and really further the central promise of the original, or at least the latest, Civil Rights Act of 1964. And if you're not familiar with that Civil Rights Act of 1964 was a huge push that dealt with the civil rights issues of that time. Jim Crow segregation, whites-only signs in restaurants, segregated lunch counters, the type of thing that the type of thing that was really the problem in the 40s and 50s and 60s, and was addressed through the Civil Rights Act of 1964. The civil rights problems of our day look a little bit different. We're usually not dealing with signs in businesses with racial segregation. They'll look more like things with like federal programs that sort people by race or sex, government contracting preferences, DEI mandates, these things that you've heard of. And so our next Civil Rights Act is intended to address the civil rights problems of our day. And so we've proposed legislation. Several of them have already turned into bills with sponsors in the House and in the Senate. And hopefully we'll be able to continue on and go through and turn into actual legislation. But here's just a list here of the things that we have included in our next Civil Rights Act. There are things like eliminating race and sex preferences in government contracting. Birth freedom in healthcare has to do with some of the things that we talked about, like with Nebraska, allowing expansion of healthcare opportunities. Civil Rights Private Enforcement and Remedies Act. One of the problems that we face at PLF is that the government gets a lot of advantages in litigation. They get a lot of protections. They've got an unlimited budget, and then there are all these doctrines that courts have developed to protect government and government officials from liability. This part of the next Civil Rights Act would help fix some of that and help make it possible to bring actions against the government when it's violating people's constitutional rights. So ultimately, the core idea behind these bills is simple. Government should not discriminate. Government should not encourage others to do so. And then the government should be held accountable when it violates people's constitutional rights. Sorry, I keep getting these pop-ups here. So that principle, I think, should matter deeply to libertarians. Individual liberty cannot coexist with the government sorting people by race. If the government can classify you by race and distribute burdens and benefits accordingly, then the individual has already been subordinated to the group. And that is the principle that we're pushing against, not just in the next Civil Rights Act, but in some of our equality legislation. And I think it's important to emphasize that the problem with the government sorting people by race is not just that the categories are crude, although they definitely are. You know, the 5 or 6 boxes that you find on every form. In an increasingly multiracial society, they make increasingly less sense. It's not just that the programs are often ineffective, although they often are. It's not just that they can provoke resentment, although they often do. The more fundamental and deeper problem is that they deny individual moral agency. And that is the fundamental principle that motivates the equality work that I do. So I want to allow any questions that you have. Before I do that, I want to close with a practical point, and that is PLF cannot litigate the cases we don't know about. So a lot of our cases start because someone notices a government abuse and reaches out to contact us. So that's one reason I'm glad to be here with this group, is that people who care about liberty often will notice things that start to become commonplace. You know, things where people are like, oh, that's just the way things work. And you know, things that people ignore, like permit conditions, discrimination in schools, licensing boards that are made up of people who actually work in the industry and are incentivized to keep other people out. Now, unfortunately, not every bad law makes a good lawsuit. We have to think when we're designing a lawsuit, we have to think about things like plaintiffs, like timing, like where's the right place to file, and what are the possible risks that we could face with developing bad precedent, which we certainly don't want to make things worse through our cases. So sometimes the better action is to push for legislative reform, or just for public knowledge. You know, make people aware of some of the abuses that are happening. But we are always looking for good cases. We're always looking for ways to push back against government overreach. And so what my first ask for you is to keep an eye out for cases. Look for people who are being blocked from using their property, who are being unreasonably kept out of a profession or being able to act as entrepreneurs, who are being discriminated against in some way by government action, whose free speech rights are being restricted by the government. Colorado has plenty of liberty issues. I mentioned some of a couple of slides ago, the housing restrictions, the oil and gas setbacks, those kinds of things, DEI programs. Unfortunately, I think we're seeing more and more of those. And whatever you think about political parties, having a state that is controlled by a single political party can lead to a lot of excesses. That's just a truth, and it's an unfortunate truth. So I guess in addition to that, so look for cases, and also send people to pacificlegal.org. That's our website. Feel free to go on there. You can learn about our cases. You can learn about our issues. You can submit potential cases through that. But being an informed citizen is helpful. We've got a great communications team. They've put together good videos talking about some of our cases. Very, very compelling. And like I said, when you've got clients like children with cancer, and families who are struggling, with whose houses and properties are being taken by the government, it makes for sympathetic and compelling stories. And then finally, I guess, don't underestimate the value of simply refusing to accept the status quo. You don't need to accept the premise that government restriction is the natural starting point. A lot of bad policy depends on people becoming tired or resigned or cynical. All of us have a variety of things that we're involved in. Nobody can dedicate all of their time towards pushing back on these things. But in a free society, rights are not permissions. The government does not get to decide whether you can keep your home equity, whether you can speak with your doctor, whether you can have a trained professional there when you give birth, whether you can produce energy, whether you can earn a living. These are all things that should not be left to the whims of bureaucrats and politicians. Government exists to secure rights, not to ration them. That's my final message for you. When it forgets that principle, someone has to fight back, and that is what PLF does. So thank you for letting me join you here tonight, and I look forward if you have any questions to ask those.
Hey, thank you.
Oh, we'll follow the microphone, if that's okay.
Hello, Jason Bailey here. Hey, that so-called affordable housing. So I'm curious. I have two questions, if I could. I'll keep them short here. On that one, do you start with the city of Denver's court system, or does it start with Colorado? Where do you start there?
Yeah. Our preference tends to be to file suit in federal court when we can. And we can usually do that if there's a federal constitutional right, like the takings clause that we're advocating for. The federal courts, it depends a little bit, but federal courts usually are a little more professional, usually take constitutional rights a little more seriously, and it's usually an easier path to get to the Supreme Court going through federal court. So that's often where we'll file. Sometimes we have to be in state court for various complicated reasons.
And by the way, when the city of Denver City Council passed that bill it's called the linkage fee, as I'm sure you know, that footage is all on video. I gave a testimony at the public hearing as a council member, Robin Leach. Of course, the linkage fee is a punishment if you don't build the type of homes we want, real cheap apartments that no one cares about, then you have to pay this linkage fee. So you could watch that video and get some ideas on how to better prosecute that case.
Thank you for being involved and for providing testimony. Too often at these city and county council meetings, you'll just get people very much on one side, and unfortunately, it tends to be a very more government-friendly side who will go and testify, and we need people to provide the alternative perspective. So thank you for doing that.
Well, hey, and then my other question, are you familiar with the lease purchase agreements here in Colorado in particular, also known as certificates of participation? Do you follow that story at all?
I don't know exactly what you're talking about. I know that we have, if it's similar to, we brought a number of challenges across the country to what they call certificates of need. I don't know if it's the same thing or not. Tell me
No, that'd be different. Well, so these lease purchase agreements are just a way to go around Tabor. Here in Colorado, we have the Taxpayer Bill of Rights. Yeah. It's a way of going around Tabor to take on $100 million in new debt without taking it to the voters, because it's a lease agreement rather than a bond.
Yeah.
But the problem is these lease agreements, they can be 20 years, 30 years, 50 years. Denver Water has a lease agreement that's 50 years. See, they don't have to take it to the voters as long as they call it a lease. And the reason is these leases, it says either party can cancel the lease at any time. Well, the financial corporation, the leasing corporation would never cancel it, of course, because they're hoping to get lease payments from now until eternity. And the other party can't cancel it because they go into the deal in the first place because they need that building or that structure. Yeah. So it makes no sense. So it would seem to me that if you were to take that to court, these lease purchase agreements, and say, hey, this is long-term debt. And of course, Taxpayer Bill of Rights says here in Colorado to any government, Glenn, that if the debt is over 1 year in term, it needs to go to the voters. And you have thousands of precedences on these lease purchase agreements that go for 20 years, 30 years, 40 years. And they say it's not long-term debt because there's a clause in there that either party can cancel it.
Okay.
So
Was that? I remember reading an article about Denver Public Schools, DPS. Were they?
Yeah, Licio, and I've met with her a couple times.
Yeah.
They've sold off most of the Denver Public Schools to these leasing corporations that they form. One particular exhibit that Licio has in her lawsuit with the Denver Public Schools, Wells Fargo gave the Denver Public Schools $869 million in principal. The lease payments, $4.5 billion. It's just completely fraudulent. These lease purchase agreements cost twice as much as bond debt. And the reason our governments here in Colorado are doing them over and over is because they don't have to take it to the voter. So that's something I would love to talk with you about anytime. Thank you so much.
Thank you.
Thanks for the talk. Yeah, I was just kind of curious about the New Jersey law. Like, don't we have anti-quota legislation, yet kind of seems like a quota that New Jersey is trying to do? How do they get around this? I'm just kind of curious.
It has been, the problem is it's been too long since the Supreme Court has decided a contracting case. And unfortunately, the last one, there was one actually from Colorado, Adirondack Contractors, but it was like in the early 90s. And unfortunately, since that time, a lot of governments have just crept towards it with public contracting using these DEI type mandates. And they won't necessarily be like a clear quota, like, you have to have this many. Sometimes sometimes they'll say, 15% of contracting has to be done by minority owned businesses. And we're trying to more broadly challenge these. What happens is we need to get one of these cases to the Supreme Court to have them say, no, like, we mean it when we say you cannot discriminate based on race. And it's not just in university admissions, it applies to public contracting. So yeah, it's unfortunately it's spread pretty broadly, these public contracting. Yep. Yeah, and 3 years ago they had a great decision in the Harvard case where they struck down. They need to do one on public contracting, and so we're trying to bring those wherever we can. My next target's Ohio, so looking at that. All right.
Hi, Dave Sauvé, first
Hi, Dave.
time talking here. On the Pung versus Isabella County case, I was raised in Bay County, Michigan, which is just a couple of counties over, so I know that Mount Pleasant area quite well. Why did Isabella County let this get all the way to the Supreme Court? We're talking about $120,000 is what the Pung family probably wants, plus costs. Why did they let it get to the Supreme Court? Because I'm sure they've spent $500,000 more, maybe up to $1 million in legal fees and trying to fight this.
Yeah.
What would drive them to take this all to stay in lockstep all the way to the Supreme Court?
Yeah. I won't pretend to read the government mind here. I'll say they think they're right. That's probably what it comes down to. Is they think that they're allowed to take property and sell it, and you're entitled to nothing more than whatever comes from the auction.
Don't they have an obligation to save the taxpayers' dollars?
Yes, that very rarely manifests itself by reasonable approaches to litigation, unfortunately. Woody.
Yeah, I have a question regarding my mother actually has she has two properties. They're neighboring, and her issue is she's trying to move the property line because one of the properties is only a 1/4 acre. I think the other property, I'm not sure if it's an acre. Can't remember exactly the full acreage, but there's a rule that in order to get a new septic system, you have to have certain amount of property, which is more than what one of the properties has. And so she's trying to move the line so that she, if needed to get a new septic, would be able to get one. And so she's getting blocked from that by the county because, well, they said they'd do it, but she has to buy two brand new septic systems, which right now the septic systems that are approved are no longer passive systems. And so a passive system, you don't have to maintain as much. So they're putting in, the newer systems are not passive, so you have to get them pumped every, year or so. And so and these new systems are like 50 grand each, and they're like, oh, well, we'll change the line, but you have to get brand new systems for both properties in order to do that. And she doesn't want to do that. It's like 100 grand. And so I don't know if that's something you guys could deal with, or if it's too small potatoes for you guys.
I don't know that it's too small. I think it's, I'm not sure that we could get a good resolution there. There's so much discretion given to the local governments. In that circumstance, the best option is probably to talk to them and try to negotiate with them, see if they'll agree to something. I don't, just from what you've described, I don't see a good case, that we could bring based on that. It's a bad situation. I feel sorry for your mom. There's probably a local land use attorney she could talk to, at least get an initial discussion of whether there's something she can do. But I probably can't help you.
So I'd assume that your greatest hurdle is individuals' complacence with their violation of their constitutional rights. And, I'm not saying that government schools are to blame there, but so what do you do as an organization to overcome that complacence and oh, well, it's what, the cop said, it's what the lawyer said, et cetera, et cetera.
Yeah. It's not always complacence. Sometimes it's fear. It is. I don't want to minimize the challenge of being a plaintiff to come, put your name on a lawsuit, and sue the government that you're involved with. That's one challenge with these public contractors. They're like, my living depends on having a good relationship with this government. If I go sue them, they're gonna come back against me somehow. Or individuals who are like, it's not worth the hassle, or I'm not sure I want to be in the news challenging something like this. Certainly complacence is a problem, and people who may not even realize their rights are being infringed on. But the bigger problem I see is just, it's hard to agree to be a plaintiff. And the way we try to deal with that, a couple of things we do. One, we offer our services pro bono. They don't have to pay our attorney fees. We are funded entirely by donors, so that our clients don't have to pay attorney fees, which is, those can run for some of our cases that'll go multi-years. You're talking about potentially millions of dollars in attorney fees. So that's one thing we do, and we're grateful for our donors for that. Second thing we do is take a very active PR campaign. We've got a great comms group, and we try to get out ahead of the news story. We have good relationships with news organizations, and we really try to push the narrative that we think is proper on behalf of these people. But even with that, sometimes we talk to people. They've got a great case. I think it could set a great precedent. They can help a lot of people, and they'll say, I'm just not sure I want to get involved on this. It's better to just lie low. So I do have such great appreciation. We always talk about our heroes. Our clients are our heroes because they're the ones who ultimately have to stand up and take on the government with all its resources and power, and push back against the government overreach. So I'm very appreciative for all our clients that are willing to do that, but it can be a challenge, and I don't fault anyone for not wanting to get involved in potentially years of litigation. But I really appreciate those who say, no, there's an important principle at stake here. I can help other people through my case and go forward with it.
Okay. I have 3 completely different questions that I'm going to ask.
Right.
So the first, I'm curious, would you guys do work on digital privacy rights cases? I'm not sure if you're familiar with the Tornado Cash or Samurai Wallet cases, but something like that, would you guys take pro bono?
I don't know enough about it to say. I just don't. I can't.
Just government coming after people for like unlicensed money transmission and threatening what's the word, money laundering charges. Like that's kind of what the money transmitter is. So if you're unlicensed money transmitter is a Patriot Act thing. So if you're moving funds in some way or another, in this particular case, these people were not within the jurisdiction of the law as written by FinCEN. They actually consulted FinCEN. FinCEN's like, nope, you guys interpreted this correctly. You are not a money transmitter. And then the Southern District of New York said, actually, we've decided you are a money transmitter, and went after them anyways. And they ended up having to plead out after $2 million in fees. So I was just curious, some kind of case like that, would you guys be open to?
It's possible. I showed those 4 areas that we work in. If it fits, if we can fit it within one of our areas here, it could have shades of property rights or separation of powers there. So the stereotypical lawyerly answer, it depends. Yeah, possibly. I don't know.
Okay, second question, totally unrelated. This is from someone who couldn't be here tonight, so I'm just going to read his question. We lost our courts of equity in the 1934 Enabling Act. Without a court capable of adjudicating equity, how is it possible for the equitable and inalienable rights to be defended?
You're getting into a little bit of legal history. There's well, I won't bore everybody with this. A lot of courts of equity. There are still some courts of equity, but a lot of in ancient England, you had this distinction between equity and law. You had courts of equity and courts of law. Those have essentially been merged in the modern American system. It's rare to have individual courts that have equity, but the federal courts, for example, do have equitable powers. So legal powers are generally make people pay money. Equitable powers are things like issue an injunction, prevent people from doing things. So there still are equitable powers in the court system, even though we don't have a formal distinction between do you have a court of equity or a court of law.
Okay, third question. Can you talk a bit more about the DEI cases? Because that seems like a massive thing that's really kind of popped up. I mean, it's been around for 50 years, but the last 10 to 15 years, it's gotten really big. I know the Oscars now have some pretty strong DEI requirements to the point that you cannot be nominated for an Oscar without hitting, I think, half your cast has to be some sort of minority. So there's the new movie coming out, The Odyssey, which has gotten a lot of criticism for some of their casting. Would some of the legal work you guys are doing, if you're able to get to the Supreme Court and get that overturned, would that affect organizations like, say, the Oscars who have done that? And is most of the DEI laws that you guys go after, is that state or federal? And kind of, do you guys know what you would target for this?
I'm not an expert on the Oscars. I believe that's probably private organizations who are acting in private ways. Sometimes under Title VI or Title VII, if they receive federal funding, they can be subject to some of these laws. But a lot of what we do is just targeting what government can or can't do. So it probably wouldn't directly affect that. I will give you an example. We've got a case in the city of Seattle. This is just a flavor of some of the DEI work we've done, where an individual, he was an employee of the city of Seattle, and they came in, and Seattle, frankly, is crazy. So they came in with this. They called it the, I can't even remember the name right now, but it was basically an all-out DEI blitz. You had to go to trainings. There was like white guilt. They had to read books on, Robin DiAngelo's books on whiteness. They would go to segregated trainings where if you were white, you had to go to this room. If you were black, you had to go to this room. He was openly criticized by supervisors and coworkers, accused of all sorts of terrible things because he was white. He ultimately quit, and we've got a case now challenging that as a hostile work environment under Title VII of the Civil Rights Act. So that case is up on appeal now in the Ninth Circuit, challenging whether you can have a hostile work environment based on government imposed DEI trainings. So that's a flavor of a DEI related case that we're doing right now.
That's our talk. Give it up for Glenn.
All right.